Okay, let's go.
Hello everyone and welcome. This is JobWatch's first webinar about the JobKeeper scheme. We can't see you, so rest assured that whatever you're wearing, you're fine. We can't see you and you can see me at the moment. I'm one of the presenters. My name is Gabrielle Marchetti. I'm Principal Lawyer at JobWatch, and I'll let Elle, my colleague, introduce herself.
Hello everyone, my name's Heloise Williams. I'm a lawyer with JobWatch and Gabby and I will be taking it in turns to speak today, but I'm handling the controls, so please bear with me.
I don't think, in fact, people could see you just then, Elle. They could hear your voice, but I don't think anyone could see you.
Oh, I see. Sorry guys, hang on.
Everyone, we do ask for your patience because it's my first time doing a webinar, and I think it's Elle's as well. So, and of course, we're in different homes doing all of this remotely.
This is me. Hello, everyone.
So we're going to be doing a little bit of chopping and changing because the two of us are wanting to co-present. We've got different slides. Hopefully you can all see the slides on your screens clearly. So let's get started. And of course, in our usual way with all our JobWatch presentations, we'd like to begin by acknowledging the traditional owners of Australia, and we pay our respects to all their ancestors and all their elders, past, present and emerging. Welcome to today's presentation. This is all about the JobKeeper scheme. You have my email address on this first slide. You have Elle's email address. You have the JobWatch phone number. And that, of course, as we all work remotely, we're all connected still to that JobWatch phone. So it will come through to one of us if you do call us with any questions. OK, on to the first slide, please, Elle. This is what we would like to cover over this next hour. We have you until 1 o'clock. Hopefully you will stay with us until then. These are the things that we'd like to talk about with you. First, we're just going to give a quick rundown about what exactly is the JobKeeper scheme. I know that you will have all heard about it. You will have all heard lots of talk about this JobKeeper scheme, but what exactly is it? Which employees are eligible for JobKeeper payments? Now, of course, there's lots of information around about which employers are eligible and information specifically targeted at employers. JobWatch, of course, is a community legal centre that gives assistance to employees. So we're focusing on employees and what employees' rights are around JobKeeper. Then we're going to focus on the JobKeeper provisions in the Fair Work Act. So these are all the recent changes that have been made to the Fair Work Act to deal with these JobKeeper payments. And I think the most interesting part for everyone will be when we focus on some of our recent calls that we've been getting. As most of you would know, JobWatch operates a telephone information service across Victoria, Tasmania and Queensland. And every single day we are being inundated with calls from employees about the JobKeeper scheme. So we're going to share some of the common questions that we're receiving, and then it will be over to you. You are very welcome to use this Teams app to send through questions, and we will try and get through as many of your questions as possible towards the end. Please note that we're not giving individual legal advice in this session. All of this information is of a general nature. It's not specific legal advice. Please call us if you've got questions that need a longer discussion. Okay, so to begin, what exactly are we talking about when we talk about the JobKeeper scheme? So this is really a temporary wage subsidy scheme. that has been announced by the Australian federal government. It's open to businesses that have been impacted by the coronavirus or COVID-19. So government has announced that it wants to help employers to maintain a connection with their employees. So rather than employers telling all the employees that can't work their full hours, sorry, we've got no work for you, off you go, you've been made redundant, you don't have a job anymore. This is going to be a way of people staying employed and receiving a payment, and the employers will receive $1,500 per fortnight from the government. And this is only eligible employers. So not every single employer across Australia is going to receive this amount. It's only eligible employers, and it's only $1,500 per fortnight per eligible employee. So both the employer and the employee need to be eligible for this scheme. Employers can top up the payment, and that basically means that if you are an employee who's working let's say your ordinary hours, or you might have even had a reduction in hours, but you are still working enough hours that warrant wages that are more than $1,500 per fortnight. So therefore, the employer will get from the government the $1,500 if they're eligible, but they still have to keep paying you the wages for all your hours that you've worked. And if they've got to pay you more than $1,500, well, so be it. That's what they have to do. Otherwise, there'll be an underpayment of wages claim. The government subsidies will start from the 30th of March. So this will be backdated because no payments have been made yet by government to employers. This will all start next week, but backdated back to the 30th of March, as long as, of course, all the paperwork has been done and both the employer and the employee are eligible. And the subsidies will end on the 27th of September, unless, of course, there's any kind of extension. But at the moment, that's when this scheme will end of September. Now, to be clear, when we talk about JobKeeper payments and the JobKeeper scheme, there are two different sets of laws that have been changed. One is the Tax Act, so there's a whole lot of changes to the Tax Act, but what we're interested in at JobWatch is the changes to the Fair Work Act. And the Fair Work Act, of course, set out a whole lot of minimum terms and conditions for employees right across Australia, for national system employees. So in a nutshell, what's happened is that with these changes to the Fair Work Act, we've got a new section now, not just one section, a new part. It's called Part 64C, and that is an entirely new part that has been added to the legislation. So that's what we are really going to be focusing on in this presentation. And these changes to the Fair Work Act they came into operation on the 9th of April, and they will end at the end of September as well, but on the 28th of September to be precise. Thanks, Elle. So, which employees are eligible for JobKeeper payments? Well, you can see from this little checklist, there's a whole lot of requirements. So the employee has to have been, for a start, you've got to be an employee. So you can't be someone who is, well, actually, I was just about to say you can't be an independent contractor. That's not entirely true because small businesses who are, for example, sole traders with an ABN are also eligible. But let's focus on employees here. Employees must have been employed as at the 1st of March. So if you were never employed by this business, PTY Ltd, sole trader, whatever kind of legal entity, and they've only just employed you post the 1st of March, then this is not for you. You're not going to be eligible. You must have been employed as at the 1st of March. You have to have been, as at the 1st of March, at least 16 or over. Now, this is one of these rules or requirements that's actually had a lot of people asking Treasury questions and the ATO, and therefore Treasury just announced last week that in fact if you're 16, if you were 16 or over as at the 1st of March, there's an extra hurdle. You must have been, or you must be, financially independent. So that means that if you're 16, or let's say at the 1st of March you were 16, but you were living at home and you were completely, dependent on your parents, then you still wouldn't qualify. And you basically need to be 18 or over if you're in that situation. So, but if you're financially independent, then you can be 16 or 17. The next point that you can see is that you must be currently employed. So if you were employed as at the 1st of March and then your employer stood you down, told you that unfortunately, you were being dismissed because there was no further work for you, you lost the connection, let's say, post the 1st of March with your employer, you can now be re-employed and you would still be eligible then for JobKeeper. That's fine. But you certainly now need to be employed. Now, you may have all heard about this next issue, which is that this is only a scheme that is available for Australian citizens or Australian permanent residents, and there's only one type of temporary visa holder that is eligible, and that is the special category 444 visa holders. They're New Zealand, a special category of New Zealand visa holders. So unfortunately, other temporary visa holders are not eligible for this particular scheme. Now, the next point that you can see is that the employee can't be receiving JobKeeper from another employer. So basically, if you are an employee with multiple employers and you are a permanent employee, whether you're permanent part-time or permanent full-time employee with more than one employer, you're going to have to decide which one you are nominating for to be on the JobKeeper payments with, because you can only be with one. If you are a casual employee with one employer and you are a permanent employee with a different employer, then you'll have to go with the one that employs you on a permanent basis. And that brings us to the next point, which is that you must have been, as at the 1st of March, you must have been either employed as a permanent, regardless of full-time or part-time, or if you were a casual, you need to have had at least 12 months of service as at the 1st of March. And you can't be receiving workers' compensation if that is for total incapacity. So you can be on workers' compensation if, for example, you are on reduced hours, or if the workers' comp insurance money is paying for medical expenses. That will be okay, you're still eligible. But if you are not working at all because of total incapacity and workers' compensation is covering your weekly, your full weekly wages, then you're not eligible for JobKeeper. And the final dot point that you can see here is that you can't be on the government paid parental leave. So it's fine if you are on paid or unpaid parental leave from your employer, provided that you are not getting the government payment. If you're getting that government paid parental leave, then you will not be eligible for that period. All right, thanks, Hel. This next slide is about what are we talking about in terms of the changes to the Fair Work Act? What are these new JobKeeper provisions? And really, these changes can be summarised as follows, that they give employers some new powers. And the new powers that employers have, and this is all about employers who are having to now make radical changes to their businesses because they've had a downturn in the money that's coming in the turnover. So what are these new powers? Well, the first is that they can issue JobKeeper enabling directions. That's the legal name given to these directions to employees. So that's one option. The other power that employers now have is to make an agreement with employees, and that reminds me, everyone, we have used some shorthand in these slides, as you can see, employers, ERS, employees, double ES, just to be clear with everyone, and JK, also on this slide, you can see is the JobKeeper. So I hope that's clear for everyone. But yes, employers can make agreements with employees to change days or times of work, and also around the taking of annual leave. And Elle will go through these in a minute. The other important change to the Fair Work Act is that the Fair Work Commission has been given some powers now to deal with any disputes to do with the JobKeeper provisions. So this is a new power that the Fair Work Commission now has, and again, we'll go into this in a bit more detail further on. Thanks, Elle.
Thanks, Gab. Okay. So like Gab has already spoken about, the crux of this new legislation is to enable employers to give particular kinds of directions to their staff while they're in receipt of the JobKeeper payment. So you can break it up into two kind of directions. So the first direction that an employer is empowered to give to their employees under this new legislation is a JobKeeper enabling stand down direction. So it kind of expands on the common understanding of what a stand down is, in the sense that what we understood a stand down to mean would be that the employee would not come to work at all. And a JobKeeper enabling stand down direction can be not for the employee not to come to work at all, but it can also be, importantly, that the employer directs the employee to work fewer hours that they're actually contracted to do. And also, in addition to the JobKeeper enabling stand down directions, an employer is also able to issue directions about the duties that employees are to perform and the location where they're to perform that. So the location could be at home, for example, and the duties could be something different to what they've ordinarily been employed to do. So they may be employed to be an administrative assistant, for example, and the employer might be requiring them to clean, for example, which under this particular legislation would be lawful, depending on certain caveats that the employer has to meet. With regards to the employer JobKeeper enabling stand down directions, so not to come to work or to work fewer hours, the employer must adhere to certain rules. So the direction that's given must be safe, having regard to all the circumstances, particularly circumstances surrounding COVID-19. And at the time the direction is given, the employer must have information before them that substantiates that the employee cannot be usefully employed for their normal days and hours because of changes to the business surrounding COVID-19. Now, importantly as well, the employee must be paid the greater of either the JobKeeper payment, which as we know is $1,500 a fortnight, or any wages earned during that JobKeeper enabling stand down period. So, for example, if an employee works 10 hours a week or 20 hours a fortnight, and that 20 hours a fortnight wouldn't enable them for some reason to earn $1,500 a fortnight by way of wages, they must still be paid that $1,500 regardless. And with regards to wages earned, if during that fortnight period they had earned more than $1,500 a fortnight, their employer must pay them their wages. So it would act, the JobKeeper payment in that scenario would act as a kind of a subsidy, if you like, for the employer to, as Gabby was saying earlier, to maintain that connection, which is the basic purpose behind the legislation. And also it's important to note as well that any JobKeeper enabling direction, whether it's a stand down or some other kind of direction, is not operative when an employee is on paid leave, so personal carers leave, for example, or annual leave, or authorised unpaid leave. So if they're away on unpaid sick leave, for example. Now, the second, so you've got your JobKeeper enabling stand-down directions, and you've also got, like we said, the JobKeeper enabling directions with regards to duties and location. Now, again, with regards to these kinds of directions, the direction must be safe. And if the duties that the employer is requiring their employees to do are different from their usual contract, and the location is also different, they must be reasonably within the scope of the business operation. So if, for example, your employer is an accounting firm, your employer can't require you to go around and mow their lawn, for example. Now, with the change to duties, and this is important, if an employer is requiring an employee to do different duties, but the duties are at a higher pay classification, for example, than their normal duties, those duties must be within the employee's skill and competency. So they can't require an employee to do anything which might put them in danger because they don't have the required licenses or qualifications. And with regards to the change in location, the location must be suitable. So if it is the employer is requiring the employee to work at a different location than their usual store, for example, it must not require the employee to travel an unreasonable distance. And again, that has regard to all the circumstances, including circumstances particularly surrounding parental and carer responsibilities. So these rules, the rules about the JobKeeper enabling directions, they're very much, these are overarching rules that must apply to any direction given. They're safeguards, if you like, that have been built into the actual legislation. So the direction, any direction given must not be unreasonable in all of the circumstances. And again, the direction may be unreasonable depending on its impact on any caring responsibilities the employee may have. Like we canvassed previously, the employer must have information before them at the time the direction is given to lead the employer to reasonably believe that that direction is necessary to continue the employee's employment. There are also procedural requirements that the employer needs to adhere to. Any direction given must be in writing, and it must be given with at least 3 days' notice, less if the employee genuinely agrees. And of course, there's always some argy-bargy about what constitutes genuinely in these situations, but the legislation expressly stipulates that the employee must genuinely agree to a lesser period of notice. Consultation, the employer must consult with the employee and they must have a record of that consultation before the direction is given. And provided that the rules are complied with, the employee must comply with the JobKeeper enabling direction, so long as the employer has complied with all the things we've canvassed previously. And this is very important, this last point, because here at JobWatch we've had a number of inquiries, a lot of inquiries from employees about if they're working reduced hours subject to a JobKeeper enabling direction, what happens to their leave entitlements? Do they continue to accrue? Do they continue to accrue, and if so, at what rate? So the safeguard built into the legislation is that if you are subject to a JobKeeper enabling stand-down direction or a JobKeeper enabling direction, your entitlements must continue to accrue at their ordinary rate. So based on your ordinary contract of employment before the direction was given. Similarly, if you're made redundant during the period where a JobKeeper enabling direction is in force, your redundancy pay, assuming that you're entitled to redundancy, must be paid out on the basis of your ordinary hours. So it would not be paid out, for example, on the basis of your reduced hours under the JobKeeper enabling direction.
Okay, now over to me, I think, and I'm just going to pause 1 second because we're getting some great questions coming through, and I would just encourage everyone to use, you should see a little tab somewhere on your screen, which is all about, it allows you to write in a question. so that we can have a Q&A session towards the end. But given that we've had a couple of really good questions on things that we've just talked about, I think I might read out these couple, and also just again to encourage everyone to send in their questions. Most of you are probably logged in anonymously, so your questions are just coming through anonymously. We can't see who you are. So one question that we've received is the $1,500 amount a gross amount in the employee's pocket, or is it or will tax, or is it before tax, so the net? And the answer is it is a gross amount. It will be taxed. Okay, so if I've heard, and of course I'm not an accountant or a financial advisor, but I have heard that if you are on a full stand down, you're not working at all, and in receipt of the JobKeeper payments, you can expect to get around $1,300 net into your bank account fortnightly. Another question that we've received is, if you nominate with your employer and then you are subsequently dismissed by that employer or you resign, can you nominate another employer, so that would be your new employer, sometime between now and September if you get a new job? And the answer, unfortunately, is no, because you have to have been employed with the employer that you're getting the JobKeeper payments through as at the 1st of March. Okay, so keep those questions coming through. Now we're going to move on to the agreements. So remember, I mentioned before that these JobKeeper changes to the Fair Work Act basically allow employers to either issue those directions that Elle has just taken you through, or to make these agreements with employees. So what are these agreements that they can make now? Well, an employer may ask you, the employee, to make an agreement about changing your duties or performing your duties. Sorry, the change to the duties is what Elle has just talked to you about, but also these agreements are about doing your duties on different days or at different times to what you ordinarily, to when you would ordinarily work. Now, so this is now allowed in the Fair Work Act, and the employee must consider such a request and must not unreasonably refuse the request. And these kinds of words, as you would all know, must not unreasonably refuse. This is what keeps lawyers in jobs. This is certainly what keeps all of us lawyers at JobWatch on our toes all the time, because every single scenario will turn on its facts. You'll never get, or very rarely will you get two questions that have exactly the same fact scenario. And so what's reasonable in one case may not be reasonable in another situation. But the wording in the legislation is that the employee must not unreasonably refuse the request. Now, any such agreement must be in writing. And of course, when the agreement is made, the employer must qualify for JobKeeper payments. And the performance of the duties on the different days or different times has to be safe, and it still has to be reasonably within the scope of the employer's business. And finally, the agreement must not reduce the employee's number of hours of work. Now, we've had lots of questions about or from callers who tell us, my employer has asked me to increase my hours. I have put in my nomination, this is all being done within the JobKeeper scheme, and I'm being asked to increase my hours. And in fact, I think we're going to share with you a case study soon with a similar sort of situation. But the long and the short of it is that that may well be the kind of agreement that that can be made within these changes. So an employee must not unreasonably refuse that request. And as I said, whether or not you've got reasonable grounds to refuse will depend on your particular circumstances and your particular facts. Perhaps you've got carer responsibilities. Perhaps you've got university commitments. Whatever your situation, you'll have to think about your particular situation and whether or not you need to agree, or would it be reasonable for you to agree or to refuse that request to increase your number of hours. But certainly the legislation doesn't actually specifically say that that's not allowed. It says that what's not allowed is for an employer to reduce your hours. It doesn't talk about specifically whether an employer is allowed to increase your hours. Okay, Elle.
Thanks, Gab.
We've also got the possibility, or employers have this possibility now, where they can ask an employee to come to an agreement about some annual leave to be taken, that the employee needs to take some annual leave, provided that the employee must be left with at least 2 weeks of annual leave. So you can't, it wouldn't be reasonable to put an employee in the position where they use up their full annual leave entitlements. Again, the employee must consider and can't unreasonably refuse this request to take the annual leave. And finally, this last point on this slide is that both the employee and the employer may come to an agreement in writing that the employee will take twice as much annual leave at half the pay, and that can still be done within this JobKeeper scheme. That's fully lawful. Okay, Elle. Now, apart from these new powers that employers have to make directions and to ask employees to come to an agreement about certain things, the other big change, as I mentioned before, was that the Fair Work Commission has some new powers. So now the Fair Work Commission can deal with any dispute about the operation of these new sections in the Fair Work Act. And they've got very broad discretion to deal with each dispute as the Fair Work Commission thinks is best in that situation. So they can have a conciliation, they can have a mediation, or they can of course have an arbitration where they would make a decision. They can also make recommendations, or they can express opinions. So these are all the powers of the Fair Work Commission. And if an employee wants to bring a dispute to the Fair Work Commission, then of course the employee does have standing. The employee can fill out a form. The form is called Form 13A, and it's available on the Fair Work Commission's website under forms. So the Fair Work Commission website is fwc.gov.au, and if you find forms, you'll see all the forms listed, and look for 13A, and that is the new form that has been developed specifically to notify the Fair Work Commission about a dispute about these matters that we're talking about today. It's not only the employee that can lodge a dispute with the Fair Work Commission, employers can as well, and of course employee organisations, so unions, or a representative of an employee can lodge, and same with employer organisations. Now, the Fair Work Commission has to take into account the fairness between the parties in making whatever orders it will make. And it does have the power to, as always, the Fair Work Commission has very broad powers. It can make orders that it considers are desirable to give effect to a JobKeeper enabling direction. It could set aside a JobKeeper enabling direction. It can substitute a different JobKeeper enabling direction, or it may make any other order that the Fair Work Commission considers is appropriate. So very broad powers. And again, remember that any Fair Work Commission order that's made is going to cease to have effect at the start of, so in the morning of the 28th of September, because that's when all these provisions will automatically come to an end, unless of course they are extended by Parliament. Thanks, Elle. I mentioned Form 13A before, and I wanted to just show you all an excerpt from that form, just so that you can actually see what it physically looks like. Many of you, I imagine, are very familiar with the Fair Work Commission's forms. They all look very, very similar. The start of the form is exactly the same as all the other forms that you would be used to, like unfair dismissal forms and GPD dismissal or non-termination forms. So basically that's where you have to put in all your details. If you're the employee, enter all your details, enter all the employer's details. But then we come to this part here that I have included in this slide, which is question 2, and the Fair Work Commission is asking you, well, what kind of a dispute is it? So please tell us, is it, you can see that first box that you could tick, and you can tick as many boxes as you want, you don't only have to pick one. So is it a dispute about a JobKeeper enabling stand down direction, or is it a dispute about a direction about performing different duties, which is the next box, or is it a dispute about a direction about location? So have you been told to work somewhere else, including from home? Or the next one, is it a dispute about a request to make an agreement about a change to your days or times of work? Or the next, is it a dispute about a request that you should take annual leave? Or is it a dispute about you wanting to have a second job or secondary employment, or to do some training, or to request professional development during a period of stand down? Or is it something else? And all the Fair Work Commission forms always have this sort of catch-all other, which again is very open-ended. It could be a dispute about something else, but remember, it's got to be a dispute about the new provisions in the Fair Work Act to do with JobKeeper. So really, if your dispute is simply about the fact that, for example, you haven't received a nomination form from your employer, well, technically that's probably a dispute, that's something to be raised with the ATO, because they are administering all that part of the scheme. So the Fair Work Commission can handle disputes about employment law matters, so these changes to the Fair Work Act that we're focusing on today, but all the other parts of the scheme are being administered by the ATO, so those concerns should go back to the ATO. You can then see question 2.2 on the Form 13A, which is the Commission asking you to explain, well, what is this dispute about? Just in your own words, it doesn't need to be anything too lengthy. Set out, preferably in short numbered paragraphs, why you are making this dispute. And further on, which is not on this slide, but the Fair Work Commission also asks in the form, what's the remedy that you're wanting? So you need to be thinking about, you need to already know what it is that you're asking. How do you want this dispute to be settled, or what's the outcome that you're after? Because you need to put that down in this form. Okay, thanks, Elle. Now, just finally, I know it's where time is ticking and we want to get on to the practical examples, because that's always the most interesting part for everyone. But I wanted to show everyone that there are civil remedy provisions. I don't want to get too technical, too legalistic, but this really just means that on this slide and on the next slide, you can see in the first column, we've said what is the section, and in the second column we've said what is the penalty, the maximum penalty that a court could order if an employer was found to be in breach of the first column, of the things in the first column. And really what I want you to note is that the penalties for each breach, so of course an employer could be penalised because of multiple contraventions, but if the employer is an individual, so let's say a sole trader, then the maximum penalty for each of these breaches is up to $12,600. And if the employer is a body corporate, then it's up to $63,000 per contravention. Now, in the very first one that you can see here, the employer obligation to satisfy the wage condition, the Parliament has actually put down two possible penalties. One is if the court just finds that, yes, there was a contravention and it's a one-off, but the other is if it's a serious contravention. And a serious contravention is if, for example, there's systematic breaches of the law, or this is happening repeatedly or en masse. And then an individual could be penalised up to $126,000. And if it's a body corporate, it's up to $630,000, the fine. So these are fines. These are not penalties that can be ordered by the Fair Work Commission. Only a court can order these penalties. So you'd have to bring proceedings in the Federal Circuit Court or in the Federal Court of Australia. But you'd be arguing as an employee, my employer has breached these provisions of the Fair Work Act, and they are the things that are listed in the first column, and therefore I'm asking you, court, to order a penalty, to order a fine, basically, against the employer. And Elle, if you could go to the next slide so that people can also see some of the other provisions that attract penalties. So you can see them here. The most egregious, obviously, the most severe is the last one. You can see here, if the employer gives a JobKeeper enabling direction, knowing that it is not authorised, that is automatically considered, because Parliament hasn't even given court the option to make it a lesser penalty. Parliament has chosen to make this the same penalty as for a serious contravention. So an individual employer, so for example a sole trader, could be fined up to $126,000 for doing this. And if it's a body corporate, the fine is up to $630,000. So this is a very serious contravention if they knowingly tell you to do something that they know is not authorised. So remember, things that are not authorised are, for example, they're issuing you a direction that they know is not reasonable, they know it's not safe. They know, for example, if it's a direction to do some different duties, they know that they are duties that are not within your skill and competency. Those are the kinds of examples. Okay, thanks, Elle.
Okay,
so over to you.
Yes, thank you.
This is the exciting part for everyone, when they get to see some practical examples.
Okay, so all of these examples that Gabby and I are going to be going through today are examples that have come through on our telephone information service. And we've selected them primarily because they keep coming up again and again. So we wanted to provide as much clarity around this issue, these issues, as we possibly could. So the first case study, if you like, is about Imelda, and she works as a casual kitchen hand in a restaurant. So she's worked for her employer for about 3 years, and her employer ended up closing its doors at the start of March 2020 due to COVID-19. The majority of the staff at the restaurant were made redundant, and some, not all, but some of the permanent staff were stood down. And this was all done before the JobKeeper scheme was announced. So Imelda recently learned that her employer has applied for the JobKeeper payments. And when she heard about this, she contacted the employer to inquire whether they intended to rehire their casual staff and nominate them for the JobKeeper payment. However, the employer said that they did not intend to re-engage any of the casual staff. Now, there's a number of things that Imelda could do in this particular situation. However, unfortunately for Imelda, it may be that the employer, if they had severed the relationship with the casual staff, that they may not be obliged to rehire. Now, I understand there might be some confusion here with regards to the one-in, all-in promise, because it's incumbent on employers, if they are nominating one of their staff members, to nominate all of them. But it could be argued in this particular circumstance that the relationship with Imelda had finished before the JobKeeper scheme was announced, so the employment relationship was over. However, in this particular circumstance, as Gabby was going through previously, it might not be appropriate for Imelda to file the Form 13A, because technically it's not about a JobKeeper enabling direction. However, one thing that Imelda could do is contact the ATO and talk to them about the fact that the employer has chosen not to nominate her as a casual staff member, or to rehire her, if you like, as a casual staff member. It might also be possible, and of course there are all sorts of other considerations that have to come into play here, such as how long it's been since the relationship was severed or the relationship stopped, in order to potentially file an unfair dismissal claim. Because we know that with an unfair dismissal claim, it must be done within 21 days of the termination taking effect. So first things first, Imelda could contact the ATO and talk to them about the employer's refusal to nominate her as a casual worker, that assuming she met all the other eligibility requirements, why they haven't nominated her. And it might also be possible for Imelda to pursue an unfair dismissal claim, provided that she's still within time to do so. However, if she wasn't within time, and she felt that it was an exceptional circumstance, for example, she might be able to apply for an extension of time. However, that would be subject to all the rules surrounding exceptional circumstances and extensions of time when it comes to either unfair dismissal or general protections termination. So that's what, with regards to Imelda's story, that's what we would, that would be JobWatch's position on that. And we would encourage anybody who is experiencing similar situations to contact the JobWatch telephone information service. The second case study we've got here is Andreas, and again, this is a really common problem that we've been faced with, or that our telephone information service providers have been faced with from callers. Andreas is a permanent full-time administrative assistant for a publishing business, and his employer has registered for the JobKeeper payment, and Andreas has signed the employee nomination form. Now, despite the fact that other staff that Andreas works with have been directed to reduce their hours, Andreas continues to work full-time hours. Now, yesterday, Andreas's employer informed him that he will only receive the JobKeeper payment of $1,500 per fortnight going forward, rather than his wages. But he's still expected to work his usual full-time hours. Now, with regards to Andreas, because, assuming that his employer was accepted for the JobKeeper payment, and assuming that this direction was given by way of a JobKeeper enabling direction, Andreas would be able to file a Form 13A with regards to this, because the employer, as we canvassed previously, the employer is obliged to pay, if Andreas is working 38 hours a week, 76 hours a fortnight, his employer is obliged to pay him his wages. And assuming that his wages would amount to more than $1,500 per fortnight, his employer must pay him that. And in that particular circumstance, that $1,500 would be by way of a subsidy for the employer. So the employer is, in proposing to do this, could be in breach of a number of different provisions under Part 6.4a. So in addition to his Form 13A, Andreas could potentially also seek legal advice with regards to proceeding to the Federal Circuit Court to see if he could bring a cause of action against the employer for breach of the civil remedy provisions. So it could be a breach of the minimum rate of pay guarantee, the hourly rate of pay guarantee, but yeah, so he would be, he could potentially bring a cause of action in the Federal Circuit Court, like I said, and he would be asking for penalties to be levied against his employer. But that is a quite complicated cause of action. So if JobWatch were to contact, if Andreas were to contact JobWatch, JobWatch would be strongly advising him or encouraging him to seek legal advice before he did that. Yeah, so those are common examples that we have come across, and I am going to pass it back to Gabby for the next case study.
Okay, so now we have Stephanie. And Stephanie, of course, just remember everyone that these are all real callers to the JobWatch telephone service. We have, of course, totally de-identified them, but these are real questions that are coming through. So Stephanie has been employed as a waitress on a permanent part-time basis for 7 years. She has signed the nomination form for JobKeeper payments. She was stood down in March when the business closed down. She and her employer agreed that she would take any annual leave that she had accrued. And I've seen someone, we're getting lots of questions. Someone has asked a question about annual leave, so this is very much on point. Since the announcement of the JobKeeper scheme, the restaurant has started operating again, but only in a delivery capacity. Her employer has now directed her to return to work, to resume her usual hours, but as a delivery driver, not as a waitress. So Stephanie, of course, is worried about whether she has to do this. She would probably prefer to stay at home and receive the $1,500 a fortnight, and she's asking us, does she need to do this? I'll actually just slightly change this in light of that question that came through, which was if you can't be usefully employed during a period and the employer directs you, employee, to take annual leave, does the annual leave have to go? Does the employee have to go on annual leave, or can they refuse? And that just brings us back to those the JobKeeper enabling, not only the JobKeeper enabling directions, but more to the point is the employer's request that an employee take leave. And so on that point, I wanted to clarify for everyone that when we're talking, I know it might sound like semantics, but when we're talking about annual leave requests within this JobKeeper scheme, it's not a direction. The employer can't direct you to take annual leave. They certainly can ask you to take annual leave, but remember those rules around the fact that you can't be expected to take all of your annual leave. You've always got to be left with at least 2 weeks of annual leave. So you wouldn't be it wouldn't be a reasonable request of the employer if they forced you, or if they tried to force you to take your full annual leave entitlement. But as long as you've still then got 2 weeks up your sleeve of annual leave, yes, absolutely, the employer can ask you to go on annual leave, and you as the employee cannot unreasonably refuse. So they're the really important words. You can't unreasonably refuse. And any agreement about you taking the annual leave has to be in writing. So that's just on the issue of Stephanie going on annual leave in the first place. But now let's come to her question to us, which is, now my employer's asking me to come back to work and do a different job, to be a delivery driver instead of being a waitress. Do I have to agree to this? And this goes to the heart of those JobKeeper enabling directions about changes to your duties, and also changes to the location potentially, because of course before she was just working in the restaurant, and now she'd be having to go out and make deliveries and working all over town presumably. But remember the rules around these kinds of directions, around these JobKeeper enabling directions. The direction has to be safe. So if Stephanie has some reason to argue or to show that this direction would not be safe in her circumstances, then she may have she may have grounds to refuse. The other thing is, of course, the direction has to be reasonable, or in fact the wording, it uses the double negative in the legislation, it must not be unreasonable. So if you flip it round, it has to be a reasonable direction in all of the circumstances. So Stephanie, if she got grounds to argue that this is not reasonable in the circumstances, because, for example, she might be able to show that there is still some waitressing work that she could be doing, and that the employer is being unreasonable by forcing her to change her duties altogether. Then, if that's the case, she could certainly fill out the Form 13A form on the Fair Work Commission's website and notify the Fair Work Commission of a dispute, and try and resolve that dispute with the assistance of the Fair Work Commission. Okay, next. Tilly. So Tilly is employed in the property management industry on a permanent full-time basis. The employer has suffered a downturn in business because of coronavirus. Tilly has signed the nomination form, and yesterday her employer informed her that they intend to cut all staff wages by 20%. All staff will be expected to work their usual hours, but at the reduced rate of pay. Does Tilly need to agree? Not only have we had this question on our JobWatch telephone service, but of course many of you will have heard this scenario because it has been widely publicised in the media with firms like KPMG and Deloitte's basically asking all their staff to agree to a 20% cut. Keep working the same hours, but have a cut in pay so that we can all share the pain. And in both those cases, Deloitte and KPMG have actually said, you know, if you're on minimum pay, so if you're on jobs that only attract the minimum pay, then you wouldn't have to agree to this cut in wages, of course, because otherwise that would attract an underpayment of wages claim. But for all the other staff, they've asked them to agree to these cuts. And the question here really is, well, firstly, I want to clarify, this would not be done within the JobKeeper scheme. This is not something that is allowed to be done within the JobKeeper provisions. However, long before JobKeeper changes came into the Fair Work Act, it has always been the case that an employer can ask an employee to agree to changes to their employment contract. So certainly it's a fundamental principle of employment law that an employer can't just make a unilateral change to your employment contract. You have to agree to any change that the employer is going to make. But of course, if you do agree, then that variation can stand. And in both those cases, Deloitte and KPMG, from what we've heard, they are just temporary variations. All the employees have agreed that for a period of 2 or 3 months, they will have this 20% cut. And after that, their wages will go back to the full, unless there's a further variation or an extension on this variation, which is always possible. But that's really the question: is Tilly going to genuinely agree or not? I mean, our concern at JobWatch is that you would have a lot of employees in Tilly's position who, when we've told her that information, we've said to her, look, Tilly, the employer can't force you, but you are free to either refuse it or to agree to that change. Lots of employees in that situation, the reality is that they're just going to feel so pressured. In order to keep their job, they will be pressured to just agree to the change. And there might be some novel arguments that can be made about coercion, etc. But at the end of the day, if the employee agrees to that change, then the change will be lawful. It certainly is not something that can be done within this JobKeeper scheme, however. Thanks, Elle.
Thanks, Gab. Okay. So the last case study that we're going to have a look at today is Bin. And Bin's been employed for the last 3.5 years as a casual admin assistant for a small accounting firm, doing 2 to 3 shifts per week on average. Since mid-March, he hasn't been getting any shifts as his employer has suffered a downturn in business due to COVID-19. His employer has enrolled in the JobKeeper scheme and Bin has signed the nomination form. Now, Bin's employer contacted him last week and is requesting that he come back to work for 1 shift per week, but to do cleaning. The employer pointed out that there's still not that many admin tasks that need to be done, but the office still needs to be cleaned. Bin doesn't really want to do this. He's pretty unhappy about this. He's not very keen to perform cleaning duties. And perhaps more importantly, he's very anxious about returning to the workplace as his partner is immunocompromised and he doesn't want to run the risk of exposing him to the virus. So Bin wants to know, or asked JobWatch, to know if he has to agree with this request or if he can refuse it. So as we've talked about with some of these case studies, and Gabby's already canvassed in one, as we know, under the new legislation, an employer can require an employee to change their duties. So they can ask them to do something they wouldn't ordinarily do. In this particular circumstance, Bin's employer is asking him to come in and clean rather than to do his administrative tasks. So as per the JobKeeper legislation, that is they can do that. That is something that an employer is allowed to do under the JobKeeper legislation. However, again, as Gabby has already canvassed, it needs to be reasonable and it needs to be safe. And the employer must comply with all the procedural requirements that they need to do in writing and that sort of thing. So his employer can require him to do it. However, with regards to Bin's personal situation, in that his partner is immunocompromised and he is worried about putting him further at risk, that's one of the things that might go to the reasonableness of the request. So he could potentially file an F13A because this has to do with the JobKeeper enabling direction given by his employer, and he could bring the commission in to make a determination, to mediate, to conciliate, potentially arbitrate, or just to make a determination or to give an opinion. However, for Bin to outright refuse to do this could be problematic, as it is something that his employer is able to do under the legislation. But again, it's always a shifting, a bit of a grey area, because it does come down to the reasonableness of the request itself. So JobWatch probably would give Bin information surrounding the F13A and how he can file that with the Fair Work Commission, and talk to him about his obligations under the existing legislation, but also his employer's obligations to make any determination or any direction that they give be reasonable, having regard to all the circumstances. Not just circumstances surrounding COVID, but all the circumstances in play at this particular time. So I think that's the end of that case study. Gab, do you have anything to add?
No, that's great. I'm very conscious of time and I'm sure people are needing to get cracking. If we can go to the next, which is the next slide, should just be over to you for all your questions. I have been reading out some of your questions. We've got over 30 questions and I'm sure most of you can't hang around to listen to all these questions. I will read out a couple. Firstly, very pertinent for everyone, I'm sure. Someone has asked, will a recording of this webinar be made available online and can we share it? Look, we are hopefully recording it. I do not make any guarantees because I'm not sure about the technology, but hopefully it's working. It's on our side today. And if it all goes according to plan, we will certainly make a recording of this available on our website. So if you please check our website, which is www.jobwatch.org.au early next week, right at the top where you see all the Q&As about JobKeeper and all the coronavirus related questions. We should have a link to today's webinar, so please check in there. Another question is, should employers discuss issues relating to family violence that employees might be experiencing if they are asked to work at home? And that's a great question. I mean, remember that with any directions that an employer makes about location of work, the direction must be safe. So if an employee at the end of the day, I mean, we are assuming, and with all those case studies that we've just taken you through, in each one of those, whenever we've said it sounds like that that direction or that request from the employer would be lawful or would be legitimate, we are always assuming there that the employer has complied with all the rules. You know, the employer is eligible, the employee is eligible, and the direction is safe, the direction is not unreasonable, and all the rest of those rules. But if the employee at the end of the day can argue that she or he has put it to the employer that working from home or working from a different location is not safe for them for any reason, whatever the reasons are, including family violence reasons, then that would certainly sound like it would make it an unsafe direction and therefore not in fact compliant with these JobKeeper provisions. If you can't come to an agreement with your employer once you've made your employer aware of this issue or aware of the risks, then certainly you should be lodging a Form 13A dispute with the Fair Work Commission. Look, I'm really sorry, everyone. We've just got so many questions. They keep flying in. We've now got 34 questions, and I'm loath to keep everyone. What I propose is that apart from making the webinar available on our website, hopefully next week, that we will also just quickly go through anyone who has asked a question that looks like it's urgent. We will give you a private answer, but also we can just summarise these questions and make the Q&As available on our website as well. So thank you so much for attending. This has been very exciting for us, I have to say, to do this first webinar about JobKeeper in these working remotely in this new situation. But it's been a pleasure, and good luck and keep safe, everyone. Thank you very much for attending today.
Thank you, guys.